Good afternoon, everyone. Can the parties confirm that they're hearing me clearly?
Yes.
Yes, Madam Chair.
Yes.
I just want to remind everyone to turn on their video. Thank you. So I am Ms. Valerie Kelsick, presiding as the panel chair for today's hearing. My other members are Mr. Raymond Smith on my left and Mr. Jason Matthews on my right. Is the applicant or representative for the applicant present? May I have your names, please?
If it please you, Madam Chair, I'm Margaret Rose. I appear with Dana Marie Smith, instructed by Mr. Brandon Raghunanan on behalf of the applicant. Present, representing the applicant today is Mr. Russell Deai and Ms. Pamela Hossain, who is the Chief Executive Officer.
You. Is the respondent or representative for the respondent present?
Good afternoon, Chair.
Please.
Good afternoon, Chair. Are you hearing me?
Yes.
Yes, Kyleton Plalsing, appearing with Mr. Ramki. Soon for the respondent. Mr. Mahis is the representative of Paria.
Thank you. So before we commence today, you would have received ground rules. I'm just going to highlight one. I'm assuming you've taken it as read, that in the event of any connection lost, you can call the hearing secretary at 627-4677 extension 1161, or you can send by email to challenge@opr.org.tt. With that being said, we are going to move along to the proceedings today in accordance with Part 5 of the Act, the Challenge Proceedings Regulations, and the Part 10 of the Hearing Rules and Procedures. Preliminary matters. The issue of the jurisdiction of the hearing panel was raised by the respondent at the CMC. However, the panel is noting that this issue was not addressed in your file skeletal submission. Can the respondent indicate whether they will be pursuing this issue?
Chair, jurisdiction was absolutely addressed in my written skeleton. I don't know how else to put it.
Okay.
It was clearly, plainly, lucidly addressed in my skeleton. I don't know how to put it. Limitation period is a jurisdiction issue. If you're out of time, then the panel has no jurisdiction.
If we are going to, do you need to continue to state your position?
Sorry, Chair, maybe I'm confused and I apologize. Are you asking me to? Well, what are you asking me exactly to do, Chair?
Well, I'm asking whether you wish to address us on the issue, or should we?
Well, the submissions are very clear. I could summarize. Most of the decisions, if not all of the decisions that are being challenged are now limited, are now outside of the limitation period. If you want to challenge the terms of a solicitation document, you have to do so before the close of the tender. That is very clear from section 52A. Extremely clear. So anything that challenges the terms of the solicitation document in October had to be challenged later that year in 2025. That's one. Insofar as there are challenges to a July tender and the cancellation of that, the cancellation of the July tender and the reissuance of a tender subsequent, if you had difficulties with the decisions, then you had to challenge that within that period of time. Well, first of all, the July tender is an entire different proceedings. So that is not before this, that is not, there's no challenge in relation to that tender. It may form part of some vague factual matrix, but that has absolutely nothing to do. That challenge, that procedure is not here. Insofar as you want to challenge a cancellation of that, again, no proceedings, no challenge proceedings has been filed in relation to those procurement proceedings. So that's out. Insofar as you want to challenge the reissuance of a tender, well, that's a challenge to the solicitation document. That's out. Insofar as you want to challenge whether or not certain things were included or excluded from the solicitation document in October, that's out. The only thing that could potentially be in is if there was sub-criteria that was used that should have been in the solicitation document. That's a fair criticism. That has been more or less admitted by Paria. We have said that we thought that the terms of the solicitation were a bit unclear. We said that we think that the terms of the solicitation could have been better expressed. And it arose from our conversations in debriefing meetings with Amalgamated and another contractor. And therefore, what has happened, they've taken the mature approach and they have cancelled the process. So the question is, as is infamously asked, why are we here? We are here, so apparently we are here because the applicant has included new relief in the form. She's asking for some probity officer, and now I see something about liberty to apply. Well, liberty to apply can't apply here because this is not a Superior Court of record. But in terms of the probity officer, conditions have to be satisfied, none of which have been pleaded: value of contract, complexity, likelihood of contention in the industry. None of those things are in the evidence. None of the things have been pleaded. And in terms of jurisdiction, as we have said in our submission, the act is the regulation is very clear. The panel can only give relief in relation to the issues that arise in the Form 8 and the reply. And that is regulation 15.2 challenge proceedings regulations. So that is the jurisdiction, and that is what I mean by jurisdiction. The jurisdiction to grant relief and the jurisdiction to hear complaints, which are statute barred, all of which are contained in our written submissions. I hope that assists.
So the question I have is, yeah, but so are you challenging whether we can proceed? Is the question that I would like to ask.
Yes. Absolutely.
And
Yeah, meaning I'm more than happy to, depending on the panel wants to deal with it. But I think the jurisdiction question and the limitation period question is a very good argument. And if you wish to deal with it now, then we can treat with it. If it is you wish to hear the evidence and treat with it in the end, I mean, we're here. So it's up to you. But yes, I can. Ordinarily, you can't give yourself jurisdiction, and jurisdiction should be determined at an early phase. I accept that. So your ladyship is right. Absolutely. Chairman is right. I apologize. Absolutely, if she wants to deal with it now. But the question,
I would like to suggest we can hear the evidence and treat with this after.
I think that's the way we're proceeding. So no difficulty.
Dr. Rose, any comments?
Well, I would hope that I would be able to be heard on that jurisdictional issue as well. Yes, Madam Chair.
Yes, sure.
Madam Chair, I understand why you may have asked the question, having had sight of my learned friend's skeletal submissions, compared to what he had in his Form 9. So in his Form 9, he took issue with these proceedings by itemizing 5 grounds that appeared to be jurisdictional grounds, challenging the jurisdiction of this hearing panel to sit on these issues. First, he said that there were no lawful grounds, and I will seek to persuade this panel that there are lawful grounds. He also said that there was no jurisdiction to hear this thing. There was abuse of process, abuse of process because the proceedings have been cancelled And because they are cancelled, this is where he was at in his Form 9. I noticed he has, he has moved a little away from this, so I understand why the question was asked. So it's abusive process because the thing was cancelled and the panel has no jurisdiction. He also argued that it was academic because all the reliefs have been granted because they have cancelled. And he, in his skeletal submissions, he seems to rest very strongly on that. Then he also went ultra-virus, that everything that we're doing here is ultra-virus. So I am glad that the panel has asked me to respond on this jurisdiction point, which my friend has now crafted in more narrow terms relating to it being academic only in his skeletal submissions. And today, as he got up and he was speaking, he was saying that we were out of time on several issues. And I would say that that is a fundamental misapprehension of the grounds that we have filed in our Form 8. It is absolutely agreed across both sides that when we filed, and it must be, when we filed our challenge proceedings, there was no cancellation. So that when we filed our challenge proceedings, the relief we were seeking, among many other reliefs that are listed in our Form 8, which I will refer the panel to, was termination. They moved quickly to cancel. And I said it at CMC and I will say it again. This is a case. It's a very, very important case because it's going to sound in what happens when bidders file a challenge and a procuring entity then cancels. Is it correct to say that the hearing panel has no jurisdiction over such a process? And this is an issue of public importance that we say remains to be addressed. But the grounds that we filed, Madam Chair, related, we had 5 grounds filed. The first ground, and I would say, and I would go to the 5th ground, which is about the cumulative effect of all of our preceding grounds, renders the entire process unfair. And if this is a situation where a public body has decided to cancel a procurement process twice after going through a technical evaluation exercise on 2 occasions for the same suite of contracts. And I think we can clearly speak to the suite of contracts here. It's 6 tender proceedings we are looking at here that we are trying to grapple with today. I don't know what time we are going to finish tonight. So this is just one of 6 that has happened. And we are saying, and this ground I think has been accepted, ground 2, that there was a failure to disclose sub-criteria, scoring system and evaluation methodology, even though the other side has accepted. We don't know the extent to which they have accepted. We don't understand fully the breaches that occurred. And this panel has the jurisdiction under the law to ascertain where there's a lawfully invoked challenge proceedings, what were the breaches of the act, and to make findings in respect thereof. You cannot cancel and then expect the OPR, which is lawfully invoked, to say, well, oh, there's nothing for us to do anymore. Because suppose there are issues relating to this cancellation and reissue, that when you go through the information before you realize that there is a clear attempt to manipulate the tenders. There are clear issues relating to the fairness of the process. Is it that technical criteria were manipulated between July, after seeing the technical submissions of the bidders, between July and October, to craft technical criteria that would support different bidders? That is an issue of fairness That is an issue of transparency. That is an issue of accountability. And that is squarely within the objectives of the Act. And so ground 3 is the failure to conduct a fair, rational, and transparent technical evaluation. And we will seek your leave to demonstrate to you how the manipulation of the technical criteria in this matter worked very severely adversely toward Amalgamated, who on all of the tenders before the various hearing panels sitting today had a lower price than the bidders that they wanted to award these contracts to. Yes, we are not at all taking a simple point. Oh my God, they were the low bid and they should have gotten it. No one is going to be making that point here. But when you have a commercial evaluation, which on their own admission, you relied on undisclosed methodologies, that is on their own admission, and you have a bidder that had a lower tender in terms of price, on the commercial aspect, questions are raised. Why did you use a different evaluation process than you put in your tender? That had you applied what you put there, what would have been the result? And these are very serious questions. And I would say why this is not an academic issue. This is not an academic issue because this procuring entity has indicated they are going out to tender again on this very same thing. It will be a third time. If we do not get to the bottom of the changes that were made, why they were made, to understand the real breaches that occurred in these proceedings, we run the risk of repetition. Again, more manipulation in an obscure way that does not bear the impetus of transparency. And Amalgamated has to make the choice. Do I put all of my stuff in again? Will they manipulate it again? Because as we will see, particularly in this tender has an issue that we are going to raise with the witnesses, that is in terms of how they treated with the technical submissions, and they eliminated Amalgamated at the technical stage wrongfully and unlawfully. They haven't admitted to that, but we need findings in respect of that. Now, Learned Friend speaks about independent probity officer. I'm not asking for an independent probity officer. What we are asking for, and it's not necessarily a belated relief. In our Form 8, we had several reliefs set out. And in the third, of course, the first two have been overtaken by events. The first one was suspension. The Office of Procurement Regulation, you have in your wisdom suspended. The second one was termination. They have cancelled. So that arguably, Learned Friend is correct, is OTOs. Arguably, it is OTOs. But the third one, at least I'm not sure I have the release in front of me, but the third one speaks to guidance and directions with respect to any retendering of this. That falls squarely within your statutory jurisdiction under Section 5010B, where you can, if issues are raised and you are concerned about the probity of an exercise under 5010B, I'm respectfully submitting that you have the power, as we asked for at C in our Appendix 3 in our relief, that you direct that any further procurement, fresh procurement, be conducted in compliance with the Act, the regulations, and the evaluation guidelines with evaluation criteria, sub-criteria, scoring systems, and methodology disclosed in the solicitation document pursuant to 5010B and H of the Act. And my learned friend cannot say that this is academic. They cannot say, oh, we are going to give the undertaking that we are going to do it, because on 2 occasions, we are seeing that they have not, because on the evidence, There was no formal notification to bidders of the cancellation. We have not challenged that decision, which is another point that I want to raise. My learned friend keeps talking about we are challenging things that are statute barred. That is not the case before your honorable panel. It is not the case. We are not challenging anything that is statute barred. We are challenging issues and decisions that arose in respect of October 32. My learned friend cannot raise straw man arguments. That is to say, you cannot raise an argument that I have not raised. Seek to refute it and think that you've made a point. Because we are not challenging the cancellation. We are woefully out of time in that. But we are saying that in a circumstance where you have issued a tender, bidders have relied on your promises in that tender. They have submitted compliant tenders. They have come highest technically. And you have then gone, and done things on the commercial end and also on the technical end. The technical side is what is working in this particular tender. My apologies, I was thinking of the other one with the commercial, but this one is the technical. You then manipulate things in the technical criteria. We have issues about the fairness and rationality of the process. And so the witnesses will come and the panel will determine whether directions need to be given to this entity if they intend to go out a third time. And it is not academic because this bidder, Amalgamated, needs to be protected. This bidder has rights. And we have a situation that if from the evidence we are seeing manipulation of the tenders, what is going to happen if they go out the third time after Amalgamated has sought to lawfully, dutifully invoke what they are entitled in law to invoke? We want transparency of the process. Had we not filed the challenge proceedings, they would have gone on and awarded this contract. This is the situation that we are in. There are also in my learned friend submissions very important issues about this cancellation. My learned friend at section 6, paragraph 61 of his submissions has said that the reason for the failure to, reason for the cancellation of the first exercise had something to do with the extraction of, not what is being given now. Where is it? Paragraph 61. There's a lot of problems around this 61. Look at what my learned friend.
Dr. Rose,
Yes.
Rose, please.
Yeah.
I think we're going into submissions. I think I'd like to confer with the panel that we can make a decision.
Chair, I want to respond with all due respect.
Please.
Okay.
No, you see, we have a problem
Okay.
today, Madam Chair. No, the problem is we have all of these back to back, and the applicant is not getting the opportunity to really have its case, which is not a simple case, presented. It's not your fault, Madam Chair, and it's not the panel's fault at all. There are statutory deadlines, but it is Paria's fault. It is this respondent's fault that we're in this situation, having flouted the jurisdiction of this panel and not filed a Form 9 in 3 days as statutorily required. Had they done that, we would have had much more time to prepare, to have things before you all in a timely fashion. This is not fair to the applicant. It is really not fair to the applicant. And then to talk about in his submissions, and I would like an opportunity to have his submissions ventilated. It's egregious what this Paria is doing in respect of this matter. Their counsel is saying in their written submissions to you that they could not access the tender documents. And yet in their documentation that they're providing to us, it's a completely different reason. There are very serious concerns here. There are very serious concerns in this tender. And if I were given the opportunity to go through all of the changes that they made and how they impacted Amalgamated, it would be much clearer to the panel that this is a manipulation situation where our ground 3 on fairness and not making a fair, rational, and lawful decision applies. I'm sorry that I'm taking up this time, but there's a lot more.
If I could just let Mr. Taklalson give a brief response before we stand up.
Yes, Chair, Gromtree doesn't even have the
Yeah.
word manipulation.
Yeah, but it says fairness.
You
It says
said
fairness.
manipulation. Chair, I thought we have
So
a
if
rule
you
about
manipulate
speaking
a
over
tender,
people. I
that's
don't know.
unfair.
I don't know if Ms. Rose doesn't want to play by the
Please,
rules.
Sorry, I should
please.
not be jumping in.
Thank you.
I apologize to the chair.
Yes, thank you. The word manipulation is not used anywhere in the grounds. Manipulation is what she's saying now, nowhere. And by the way, in terms of straw man arguments, it's not straw man arguments, you know, it is literacy. Let us look at the very first document filed, the Form 8. What are the decisions being challenged? The decision being challenged is the award to a contract by Allied Security. That's the decision. The second decision is non-disclosure. There's nothing here, either in the grounds, the forms, the solicitation, the submission, about Paria manipulating any process to favor anybody. Not even any submissions that was filed. But today, we have sermonizing about manipulation and unfair and amalgamated. Of course, they have rights. They file their claim. What other rights do you want? And it is very, very clear, very, very clear, that my friend is misconceived about her own application. Look at the relief. Let's look at the relief that she seeks. A is gone because it's a suspension, right? They want the suspension. There was nothing to suspend. B, procurement proceedings be terminated. Well, it's cancelled, gone, right? C, she wants a direction that we follow the law. That's all it is, you know. A direction that we follow the terms of the OPR. You don't give a direction for that. Everybody has to follow the terms of the OPR. And if you feel that we didn't follow the terms of the OPR, we have to file challenge proceedings or ask for an investigation. D, require the payment of compensation for reasonable cost. Well, we only got that form today. Let's not particularize that at all. And then E, take any other action. Well, I don't know what other action you could take. And there's this thing about probity officer. It's nowhere in the relief. If you wanted that, you should have put it in the relief. What has happened here very clearly? My friend has seen her case evaporate. There's nothing. It's statute barred. It's gone. And now she wants to convert the case to talk about manipulation of criteria. There's no manipulation. There's no evidence of manipulation. In fact, if you read the entire witness statement of her witness, he doesn't even give evidence of what is manipulation. He says there are changes, and he doesn't complain about the changes in the witness statement. And this unnamed person that apparently we are manipulating the contract for, that allegation is not pleaded, and it's not in the witness statement either. So there's no evidence of it, no pleading of it. It's not in the Form 8. It doesn't arise in any of the issues. And for you to now want to use challenge proceedings as an investigation, right? That's what she's encouraging the panel to do, you know. Use challenge proceedings as an investigation into every fact and matter from the July tender to the October tender to the March cancellation to see if she could uncover evidence of manipulation. That is an abuse. That is not the purpose of challenge proceedings. She should have asked for an investigation and made a complaint. That's a different jurisdiction. But you cannot use challenge proceedings to launch some roving investigation, particularly in relation to a cancellation that took last year and a reissuance that took place in October when you're out of time for it. So, with all due respect, absolutely no merit in this claim, absolutely no merit in these grounds, and of course they're statute barred. And I want to put on record that if the tribunal ought not to be misled, do not go down the road of making orders which you do not have the power to do. That is ultra vires and illegal. You cannot order a probity officer in this matter. Absolutely not. And that is the only thing that Ms. Rose is asking for, that to put it in this matter. The only thing. You can't do declarations. You may give directions, right? But you cannot order a probity officer in this matter. It simply does not arise. And if you wanted it, you should have it included in the relief. And in any event, if you wanted it, there are preconditions in your guidance document for probity officers, high value contract, complex, etc. Again, no evidence of it, no argument of it. in the grounds. You have to say in your grounds that we want a probity officer because of A, B, C, D, E, F, G, and allow Paria to respond. Pleadings is about fairness. She complains about fairness, but she wants to ambush us with relief she didn't claim. Sorry, Dr. Rose didn't claim. Absolutely wrong. Absolutely wrong and absolutely inappropriate. So, with those submissions, perhaps we could start taking evidence.
Madam Chair,
And one other issue.
it is unfair to have my
there's
friend.
One moment,
absolutely
please, members, please. Mr. Taklalsingh, are you finished or you have another?
Well, I'm finishing my reply. If my friend speaks again, then I want to speak again. So she either has to put it in writing or we could start the evidence because my witnesses have been here all day. My legal team is here all day. As I'm sure you are, some of us haven't eaten. So we should really get on if we're going to get on. I think that's the best way to. And the public importance, there's no public importance.
Thank you, Mr. Taklalsingh. Just allow Dr. Rose to reply and then we'll stand down to make a decision.
Reply to reply.
Yeah, but I was not.
You had your hand up, Dr. Rose?
Yes, I was not finished. And we heard Mr. Taklalsingh go on for such a time, and I was not finished. There in our reliefs, I was going through the reliefs, and I had stopped on the third one about the re-tendering exercise and directions on re-tendering. It's not merely on complying with the law, yes, but having regard to what we unearth through the witnesses, there may be specific directions we want to give in respect of this procurement exercise that has gone through two cancellations, relating to how they treat with evaluation methodology, relating to how they treat with technical criteria, evaluation methodology for commercial criteria, and all of that. We can specifically get directions in respect of that. We also have section 5010H, which we pleaded from the time of our Form 8. And in our form, in that, we said, take any such action that is appropriate in the circumstances. And our argument that if the evidence bears it out, we could not have put tender manipulation until the disclosures were properly made to us. The disclosures were not even properly made until today. Even though this panel ordered the disclosures to be made, we requested disclosures since April 17th. On March 23rd, they didn't give it to us. We are dealing here, if we are talking about an abuse of process, we are dealing here with a procuring entity who has abused the process by canceling a tender, not sending notification, and we're not challenging that, but it's a history and a pattern of conduct that I ask the panel to take notice of, and ask yourself whether the present tender is safe. They have canceled, but you need to ask yourself, what do we do in a situation like this where there have been two cancellations? Can we trust Paria, who cannot even come here and accept what the OPR has on its record, that they were served on March 26 with these proceedings to date without leading any evidence, but just allowing their counsel to speak from the bar table? They are casting aspersions on the Office of Procurement Regulator, serving of this proceedings on them. So basically saying that you all have breached the act. I mean, this is the conduct of this particular public procuring entity. And we have to ask ourselves why they are treating with this matter in the way that they're treating with this matter. And at the end of the day, you do have jurisdiction. Your jurisdiction is in law. It is not in Mr. Taklalsingh's opinion. It is in Section 49. We have pled the two grounds of Section 49 and in Section 50. That's the jurisdiction that you have. And there is nothing in the law that says if a process is cancelled, that jurisdiction unilaterally cancelled by a procuring entity, that jurisdiction is divested from the hearing panel. That would make a mockery of this system. If as soon as something is challenged, a procuring entity can cancel, and we say no, the hearing panel has its hands tied. That is not the case. And the fact that they said they are going to retender means there is practical utility in these proceedings. Practical utility is that this bidder would need to be protected from action that Paria may take. And that is why we have asked, having regard to Paria, after 2 weeks later, coming and saying, what they wanted to say, that they weren't served with things and all of that. We said, you know what, this bidder is demonstrating, not bidder, this procuring entity. There is, and in my written submissions, I will have to lay it out. So I'm going to ask your, Madam Chair, for you to wait on my written submissions, because it is not fair. You ordered skeletal written submissions, and we were to have the opportunity to ventilate that here today. It is not your fault that it is unfair to the challenger, but it is unfair that we are not able to sufficiently ventilate our submissions on jurisdiction. And I'm going to ask you to allow the written submissions on this to come in before you are lured into error by this procuring entity. There is the authority of Salem, which I've put before your lordships. Even the authorities passed by my learned friend demonstrate that if you're looking at whether something is academic, it means that there's no further relief that this bidder can get. There is obviously further relief, compensation for the bid preparation costs, directions that can be given, and yes, independent probity advisor being appointed in this matter for any third attempt at this particular procuring exercise. This independent probity. Okay.
Thank you. Thank you. I think at this stage, I'm going to need to conclude the panel.
Chair, I have to respond to two things. I have to respond to two things because allegations are being made about me now. So I have to respond to two things, right? The first thing is, in terms of my friend says she had her full disclosure prior to skeletal submissions. Skeletal means you make skeletal points as to what you want to say. You had your full disclosure before that. Not a single line in the skeleton submission about manipulation. And certainly nothing to cast aspersion against me. So that's the first thing, right? Second issue in relation to this is that when we say jurisdiction, we were very clear. Nobody here accused the panel of anything illegal or whatever. We were very clear. It's a limitation issue. It's a relief issue. Your relief could only be crafted on the issues that arise in the pleadings. That's in your regulation. Kyle Taklalsing isn't saying that, with all due respect. The regulations of the OPR say it must arise in the format and reply. No request for probity, no manipulation, nothing like that. So it's either we follow our own rules or we don't. And that is your rule, with all due respect. That's all I was saying. So I hope it wasn't taken to me saying that you're acting illegally. Ultra-virus is a term that is used in law regularly, right? So I don't think it's that. So when I say this, nothing personal. Yes. So those are my
suggestions. We can wait on submissions. We're going to stand down for 1 minute. I need to confer with the panel and we'll come back. Thank you, members. So since the Respondents' Council has limited the scope of its jurisdiction point, the panel is minded to proceed to hear the evidence. The parties, you can fully ventilate the jurisdiction issues, including limitation and abuse of process in your closing submissions. Having said that, I just want to go to housekeeping matters. So have all the witness statements filed by the parties on the 20th of April been served? Dr. Rose?
Yes, I'm being told yes. We
Mhm.
have.
They say everybody else is
Uh,
Yes, we have as well.
And how many witness statements? Okay, how many witness statements were filed and served?
I think there would be three, one from us and two from the respondents.
Okay. And all these skeletal submissions as well filed on the 21st of April? Please
Yes,
confirm.
please. Yes, please.
All evidential objections filed on the
Confirm.
21st of April. And the disclosure order dated 17th April.
Say no.
Oh, you didn't know? Sorry. Which, I'm sorry, who said no? Can I go back to all evidential objections were filed on the 21st of April?
Chair, we didn't avail ourselves of evidential objections. And I haven't received any evidential
Okay.
objections.
Same here, please.
Okay. And the disclosure of the documents dated 17th April, have those been served?
Yes, Chair, and I don't know how to put it that given the last I know we shouldn't mix, but let's just say that it was
Yeah.
communicated to me from the other side what was the substance of the disclosure, and I have done that in advance for this hearing, so that shouldn't be an issue now.
Okay,
Confirm that we have received it.
Okay.
And we thank Mr. Takalal Singh for
Okay.
his activity on this one.
and the applicant, you also submitted an MP4. He said, has the respondent received the recording? Yeah. Is that Taklasan, the MP4?
We couldn't access it, unfortunately,
You have no objection to it.
but we have no objection to it. It is
Okay. So are there any preliminary matters either side wish to raise before we move to hear the presentations?
Not on my
Margaret.
end, Madam Chair.
Any preliminary matters?
So,
I think we deal with all preliminary.
okay, and so that if you have any issues that are live, whether issues have been refined or whether new issues have arisen post submission.
Chair, I think the way to deal with that perhaps is we do it in our final submission, written submission tomorrow. That might be the smartest way to do that. Yes.
Thank you. So we want to go to the witnesses. Are the witnesses present and able to give evidence and be cross-examined?
Yes, on my side, Chair. Yes.
For the applicant, we have Mr. Russell Deai. Is he present?
Yes, he is, Madam Chair.
And for the respondent, we have Mr. Sheldon Subaru and Mrs. Marissa Ragir.
Yeah, yes, Chair.
Yes. Okay. And so I need to understand if any of you would wish to make a 5-minute opening statement and or call your witnesses.
I think the phrase is ditto.
Oh.
We've done that, exhausted that.
Yeah.
You've done that. Thank you. So I now invite Dr. Margaret Rose to begin her applicant, but to bring the applicant into the room, can we bring
Chair,
Mr. Deai in?
Chair, just one issue, I apologize. In terms of time management,
Okay,
cross-examination, yes.
so how much time would you require, Dr. Rose? You have one. How much time would you require?
I have two witnesses. I think, having regard to some ground that we will put into our submissions, I am going to attempt to do the two witnesses for terminaling within half an hour. That's what I'm going to attempt to do, 15 minutes each for the two witnesses. But give me just a little, maybe 20 minutes each, if possible. Yeah, but I'm going to try to
So
do it
half an hour,
succinct as
30 to 40 minutes.
Yes, I'm going to do my best, Madam Chair.
Chair will check. I know Dr. Rose will keep her promise, so I will limit mine to 20 minutes, and we could work from there.
Thank you.
Yes.
Start with, can we bring the first witness in? We started with who shall we start with first?
Oh, sorry,
Mr. Russell Deai.
Mr. Russell Deai, he is present in the room. And
Oh, yes, there he is.
Madam Chair, you will administer the oath to him, and then I will tender the
Yes.
witness statement as evidence in chief.
Good afternoon, Mr. Deai. Are you hearing me?
Yes.
Please raise your right hand and repeat after me. I state your name.
I, Russell Deai,
Solemnly swear that the evidence
solemnly swear that the evidence
I shall give to the hearing panel in this case
I shall give to the hearing panel in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Can you please state your name and your position?
Sure.
For the record.
Russell Deai, Marketing Manager, Amalgamated Security Services Limited.
Madam Chair, would it be possible for the witness to be shown his witness statement?
Signature, yes.
Thank you. Mr. Deai, you signed and you produced a witness statement in support of these challenge proceedings,
Yes,
and you executed it as being true and correct to the best of your knowledge and belief.
yes,
If you were, this was on the 20th of April, 2026.
yes,
If you were to see that statement again, you would be able to recognize it.
yes.
How would you be able to recognize it?
By the content and by my signature.
Yes. Do you see on the screen?
Yes.
So are you able to identify anything on that screen?
My signature and the declaration.
This is your statement.
Yes.
Madam Chair, with your leave, I'd like to tender this statement and submit it as evidence in chief for this witness, please.
Accepted. Yeah.
And I hope that I don't have to object too much. I try not to
Please
object too
proceed
much.
to cross-examine. Yeah.
Mr. Deai, sorry, are you hearing me?
Yes.
Yes. One of the main issues you raised in this hearing is the cancellation of the July tender. I'm going to call it that. Is that so?
The July tender for terminaling and
Yes. We are in terminaling
and
proceedings, so assume that everything I talk about is terminaling, unless you need to correct me, okay?
Well,
So one of the major problems you had is the cancellation of the July tender for terminaling, correct?
terminaling and refinery and environment.
They were joined together, yes.
It was one tender.
Right. So you had a problem with its cancellation, correct? Is that a
Yes.
problem? You did
Yes.
have a problem with its cancellation?
Yes.
When were you informed of the cancellation?
I don't remember when exactly.
You say in your paragraph 22 was around August that Paria gave notice. Is that
Yes.
right or wrong?
Yes.
That's right. So in August 2025, you knew about the issue which you had a problem. Is that fair to say?
Yes.
Took no step, took no legal step, correct?
Correct.
Wrote no letter, correct? Wrote no
Correct.
letter of complaint, correct?
Correct. Correct.
Made no application for same to be investigated by the OPR, correct?
Correct.
Didn't raise it with Paria, correct?
Correct.
Good. The tender was then reissued in October, correct?
Correct.
When the tender was reissued, well, prior to that, in this one, you got an extension, am I right?
Yeah.
Right, so your contract was extended, right? So you got a notice of extension of contract, and then a new tender was issued in October, correct?
Correct.
Yes. And when you found out about the decision to reissue, well, wait, before I go there, the previous tender in July, that's a separate procurement proceedings, correct? Had a different procurement number, yes?
Yes.
Right. And the procurement proceedings that were the solicitation documents that were issued in October, that carried a different procurement proceedings number, correct?
They carried two different procurement
two.
numbers
Even
because they
better.
were split into two.
They were split. Right, good. So let's just deal with refinery. So the refinery carried a different number, correct? Terminaling. I apologize. Terminaling, correct?
Terminaling, correct.
Right. So when the decision, when you found out about the decision for a new process to be embarked upon, a new solicitation documents, again, did you object?
No.
Took any legal step?
No.
Wrote any letter of complaint?
No.
Produced any contemporaneous document that either Amalgamated or yourself had a problem with that?
No.
No. And when you got the October tender, according to you, maybe this is animated. You got the July tender, you compared it with the October tender, correct?
Well, it was split into two.
Right. I'm making that mistake, but I think you know what I mean. When you got the new tender, the new solicitation documents, you compared it with the old solicitation documents.
Correct.
Chair, 1 second. A pop-up has happened. Yes, okay, good. We're good. Yes. A pop-up happened in my computer screen. I apologize. Good. So you made the comparison between the old solicitation and the new solicitation, correct?
Correct.
You noticed differences, correct?
Yes.
Did you make any allegation of manipulation?
We considered that we wondered why it was split.
Right? You wondered why it was split. Okay, fair enough. Did you complain to Paria about differences between July and the October? Did you make any complaints?
No.
You are aware that the OPR was in existence last year at the end October, November, correct?
Yes.
Did you make any complaint to the OPR about this? Saying it was unfair or unjust or anything like that?
No.
File any challenge proceedings?
No.
Good. Now, you then identify differences according to you in the criteria. Yes?
Yes.
The criteria of the July solicitation documents and the criteria of the October solicitation documents, correct?
Correct.
At that time, did you raise any issue with Paria about any omission or addition being unfair?
No.
You did not. At that time, did you write any letter of complaint to Paria about any addition or omission in the solicitation documents being unfair?
No.
Good. Did you make any complaint at all to anybody about the documents being unfair that you documented. Let me put it like that.
No.
Good. So you then saw that you had this new solicitation document, but according to your witness statement or according to your case, you have difficulties in some of the things contained in the solicitation document of October. Is that correct?
Yes.
Among other complaints, I know your counsel, but that's before that. But among other complaints, one of your major complaints is there are things in the October solicitation document, the terms of the solicitation that you have a problem with. Correct?
Correct.
And those things are changes of criteria, sub-criteria issues, correct? Yes?
Yes.
And before the close of tender, you did not raise those issues for clarification, correct?
No, we asked for clarification on some issues.
On
And
some
it's
things, but
in-
nothing that you complain about now, correct?
Correct.
Right. So your clarification process, you utilize your clarification process. Well, am I right in saying a clarification process is for you to get clarification on the solicitation documents? Yes?
Yes, but we used it for operational
Something else.
issues.
So you went a little further. You used it to actually raise an issue, correct?
Yes.
Right. So you accepted that your clarification process, you could have raised issues, but you did not raise any issues. Am I right?
The time lag between when we would raise an issue and get a response was extremely long. So we tried to raise as few as we could.
Okay, that's fine. But you, at the end of
Mr. Clarkson, sorry, Dr. Rose has a.
oh, I apologize.
Dr. Rose, we're not hearing you. You're muted.
I'm loath to intervene on my friend because we want to get to the end of this really, really quickly. But what is the relevance of this line of questioning where there is a duty on the procuring entity to do what they have to do? There is no duty, statutory duty on a bidder to help a procuring entity to correct their own document. So I don't know what is the purpose of it. If we had all day to do this, of course, I would not object. But I mean, we have several and we have several other matters to deal with, and we have a lot. So I'm saying, what is the relevance of this?
Can I proceed, Chair, or you entertain that objection?
Yes, please.
Yes, thank you. So moving on, in relation to the, and I'll just summarize. In
Sorry,
relation to
Mr. Clarkson.
yes.
Sorry, could you just respond to the objection on relevance?
Well, I've spoken about jurisdictional limitation. If you have problems with the publication, with things published in the solicitation document, you have to raise it within a certain time. And the point is, I've established an evidence that he did not raise it in the established time. So that's irrelevant. And insofar as we are talking about probity and genuineness, I have also talked about this claim being an abuse of process. And therefore, it is relevant if the complaints are only a problem now in March 2025 when they were informed that they may not win the contract, as opposed to when they had the contractual ability to raise it and right to raise it. So that's the relevance of the questions, and I think I'm entitled to probe. It is almost axiomatic that lawyers are entitled to probe the contemporaneity of complaints when persons bring them in litigation. So I think I'm entitled to probe that, with all due respect.
Thank you. We overrule the objection. Please proceed.
Yes. So moving on, and I won't detain you there too long. So some of the things change, and I don't want to spend too much time on that because I know I'll be objecting to Dr. Rose's line of questioning here. But some of the things changed. Some of those things that changed between the July and October, wouldn't you agree with me that some of the changes were to demand higher standards?
Not necessarily.
Okay, so for instance, there was a requirement that officers move from a certain amount of months, I think it was 24 months to 36 months experience, correct?
No.
You don't remember that in the solicitation documents? That from the July, there was an increase in the terms of months?
Okay,
Yes?
yes,
So Paria was asking for more experienced officers, correct?
yes,
Right. And in fact, one of the problems you had is that some of your officers did not have the secondary school certificate, correct?
yes.
Yes, correct. So some of your
Mr.
officers,
Taklasin, Mr. Taklasin, sorry, Dr. Rose.
but he's answered. He's answered yes.
Dr. Rose, your hand is up.
We have three matters going on. That is not the evidence in this that has been
Okay.
put in respect
Is it
of
not?
this terminaling.
Okay. Terminated. Okay, well, I mean, that could be dealt with in written submissions. It's either it's there or not. So I'll move on. All right, I'll move on. There was an increase in health and safety requirements, correct?
It
Or the
was,
amount of things you had to satisfy to get past in health and safety, correct?
Right, it was a
Was
not
a pass
gate
fail.
any made. It was.
Right, it was a pass fail, and then it
person.
went to, we want more criteria and more things from you, correct?
Yes, it was 75% or something like that.
Right, now, Mr. Deai, nobody here, and I don't mean to sermonize, nobody here is suggesting that things were perfect, right? And that there were no mistakes. You're aware that Paria has now admitted it made some mistakes in the documents, correct?
Yes,
Right, and they've accepted that, look, certain criteria, certain sub-criteria should have been included. You know that now, correct?
yes,
Right, but you also agree that some of the changes, it seems that there was a genuine intention to try and increase standards, correct?
I guess.
Yes, I guess. So that in terms of Paria, using these changes to manipulate and push the bid somewhere else and advantage Amalgamated and all of these, you know, I don't know who can advantage Amalgamated, but treat Amalgamated unfairly, right? You don't talk about that in your witness statement, correct? You don't give evidence of that.
No,
No, you don't. And you understood, sir, that when you were preparing your witness statement, you were trying to give evidence to assist the panel, not so?
yes,
And you understand that you have a duty to be full and frank with the panel, so that you have to put your whole case and all of the relevant evidence in your witness statement, correct?
correct.
Good. Chair, 1 second. I think I may be finished. 1 second. Could I just confer with my co-counsel to ensure I didn't miss anything? A bit fatigued this afternoon.
Oh.
Yes, much obliged.
Mhm.
Only because, and I hate to be repetitious, we'll do this very quickly because I know what you're going to answer. You're not a shareholder, you're not a director, correct?
Correct.
And you get your authority from the board of directors, correct?
Through the CEO, correct.
Truly right. And your authority for these proceedings comes from a certain board minute that is annexed in appendix 1 of your documents, correct?
Correct.
Right. One of the decisions you challenged, sir, took place on the 24th of March, correct? What
No.
the non-disclosure, the decision not to disclose documents, that took place on the 24th of March, correct?
No, that took place
The
when we
20th?
had the debriefing, which
So-
was the 17th.
So you accept that, okay, but so you accept that in your grounds of challenge, you identify that the decision of non-disclosure took place on the 23rd of March. I showed you that, correct?
Yes,
Right. So you accept that in your grounds of challenge, you identify that the decision you want to challenge took place on the 23rd of March, correct? May have been an error, but the point is it's there in the grounds, correct? Yes?
yes, but
Good. Thank you for being honest. And you accept that your board minutes are dated the 17th of March, which was prior to that decision. Listen to my question. You accept that the board minute which you are next is dated the 17th of March, which is prior to the 23rd of March. Very circumscribed question. Yes or no?
It is because of the
Thank
fact
you, sir.
that
No
we
more
had
questions.
the meeting
No,
on the
no, sir.
17th.
No, I'm not asking. Yes or no? Thank you. I didn't ask for
On
explanation.
the 17th is when we requested it.
Okay, sir, fine. No
And
problem.
a verbal request at that point is still a request.
Sorry, just about that. I don't want to get prolonged this. What did you say? I just didn't get it. What you said last?
When we had the meeting is when we requested it and we didn't get it. So that's why.
Okay, good. And then you wrote a letter, correct? And then you got a response
Correct.
on the 23rd, correct?
Correct.
And is that response you have a problem with, correct? Because they didn't give you everything.
No, it should have been done on the 17th.
All right, no problem. Chair, I won't push that any further. No more questions.
Dr. Rose?
Just one question around the board minute. Please. Yeah,
I'm sorry,
so-
Mr. Oh,
So in that board minute, you were authorized to take all such further action and other steps and execute all such documents as may be necessary or desirable to support the application that you're bringing here and the decisions that you're challenging. Yes?
So, yes.
Right. I have nothing further.
at this point, I'd like to check with my panel members. Do you have any questions for the witness? Okay. Thank you. Mr. Deai, your excuse. Thank you.
Okay.
Yes, Chair, I will move to call my witness. I'll just need to send my setup. So, Chair, I'll just set them up with the laptop. No, they're in a separate room, as I said, so that there's no.
5-10 minutes. How long do you?
3 minutes, Chair, or 5 minutes.
Okay.
We could just come back in 5
Okay.
minutes.
We'll come back in 5. Yeah.
Much obliged.
Mr. Subaru, please turn on your camera and we'll wait for Mr. Kalsin to join.
Mr. Chairman, Mrs. Chairman, just 1 minute. Oh, Mr. Tucker, I think it's back in your.
Apologize, Chair.
Okay.
Okay, it's back. Yeah. And proceed.
This one.
Subaru, we're about to allow you to take the oath.
Chair,
Are
your
you
camera
hearing
is
us?
off. Chair, your camera is off, just to let you know. I don't know if you know. Camera, there.
Yeah, we'll
you-
turn it on after he takes the oath.
Oh, I see, I apologize.
Good afternoon, Mr. Subaru. Please raise your right hand and repeat after me. I state your name,
I, Sheldon Subaru,
solemnly swear
solemnly swear
that the evidence
that the evidence
I shall give to the hearing panel in this case
that I shall give to the hearing panel in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Mr. Subaru. Can you confirm that you gave a statement on this matter and that the document that you see on the screen has your signature and the date of the document?
Yes, I can confirm I gave a statement. The signature on the document on the screen is my signature, dated the 20th of April, 2026.
Thank you. So I would like to indicate that we are now tendered and mark this as the initials for Mr. Subaru. Can we proceed to cross-examination?
Thank you very much, Chair.
Thank you. Mr. Subaru, very quickly, we're going to go through a couple of things because we've seen each other already for today. How long have you been working at Paria?
I've been at Paria as a security lead since July 2019 for 7 years.
For 7 years. And during that time, how many tenders have you been involved in?
I would have been involved in approximately 5 tender processes.
Do you have any procurement training?
I have no formal procurement training.
Right. On terminaling, on this particular contract, Amalgamated was eliminated at the technical stage. Is that correct?
That is correct.
And they were eliminated because they got 68 points on technical and the minimal threshold was 75. Is that correct?
They were eliminated because they did not meet the minimum capacity requirement, resource capacity requirement. They did score 68 in the technical evaluation.
But in your terms of the ITB, you indicated that in order to move forward to the commercial stage, the bidders needed to achieve 75 as a minimum threshold on the technical evaluation, correct?
That's correct.
Yeah, I'm going to try to do it as quickly as I can without showing you the documents.
Right.
That's there's contention, right? And Amalgamated got 68 and therefore did not meet the minimum threshold of 75 and they were eliminated, correct?
That's correct.
Now, you were present at the debriefing on the 17th of March,
Yes, I was.
right? When Amalgamated, through their representative, asked you, well, why did we get 68 for technical capacity, technical criteria. Yes?
Yes, I was there. Mhm.
And what was the explanation that you gave at that time?
I believe it was that they didn't meet the minimum resource capacity requirement.
And what were the minimum resource capacity requirements?
For the terminal in tender, the minimum required was 20 security officers and 6 estate constables.
Now, who was responsible for this evaluation exercise?
I was the technical authority that led the evaluation exercise.
And so you of the view that Amalgamated did not meet the criteria of 20 security officers and 6 estate constables.
That is correct.
And you looked at that and verified that for yourself.
I was part of the evaluation team that looked at the profiles that were submitted. Yes, I verified it as well.
Now, when you were in that debriefing, it is true to say that you indicated to Amalgamated that they were eliminated because they got 0 on resource capacity.
I believe the conversation was that they got 0 in that section of the evaluation because they did not meet the resource capacity for those staff, those profiles.
Right? I'm hoping that we don't have to go to the recording and to the documents. In that technical evaluation criteria, would you accept that there were three categories under there? Resource capacity, worker, where's
Work experience.
work experience, and
And management
execution
systems.
plan and management systems. There were 3.
Yes.
Yes, that added up to the 100.
That's correct.
Yes, and let me just pull it for my own thing, but at resource capacity, you accept that when you were at that debriefing, you indicated that Amalgamated got 0 for resource capacity.
I can't recall if I indicated that they got 0 for resource capacity during that meeting.
But you were in that meeting.
I was in the meeting.
You heard Ms. Ragir? Ms. Ragir was in that meeting?
She wasn't also in the meeting, yes.
Who else was in that room?
From Paria would have
Yeah.
also been Mr. Ragir.
And anyone else?
The remainder of persons were from Amalgamated, which should have included Mr. Russell Deai.
Yes. You did not hear Ms. Ragir indicate that that Amalgamated got 0 for resource capacity?
I could confirm that mention was made about 0 in that area, but it was for the section that I was being assessed. And if I may explain, there was part of the resource capacity that was allocated for key personnel, which Amalgamated got 10 points for.
No, this is what you all came with after. But when you were there, you'll tell the honest truth to this panel. You indicated, well, I'll have to play the recording. You and your colleagues indicated that Amalgamated got 0 for resource capacity out of 40 marks. Is that not so? 0 for resource capacity?
I can't recall that being specifically said in that particular meeting. There were 3 debriefings on that morning. I am not sure that it was said in that particular meeting.
Oh, but if I put it to you that is what was said, would you say that is not so?
I'll accept so.
All right. And I want to suggest to you as well that what was said in that debriefing is that you would have scored 0 and you would not have progressed further?
Would not progress beyond the technical evaluation stage.
You would
As
accept.
mentioned, I can't recall exactly what was said, but it was part of the discussion.
Yes, well, the panel will have the evidence before them on
Right.
what was said at that debriefing. Now, you would accept and let me, for the purposes of the record and for your notes as you go forward, it is at 33 minutes and 35 seconds into the audio recording. So I'm putting that on the record so that the panel can hear, can access that information. Now, you would accept. Is this it here? Yes. So for resource capacity, the maximum you could have gotten was 40 points, yes?
That's correct.
For work experience and client references, the maximum you could have gotten was 30.
Correct.
And for execution plan and quality assurance, the maximum you could have gotten was 30.
Correct.
You would accept that if Amalgamated got 0 for resource capacity, that it would be impossible for what was said to them in their standstill notice, that they got 68 points. You realize it would have been impossible for them to have gotten that 68 points.
That is correct.
Yes. And so that is what was said at the debriefing. You recall at the debriefing that we requested the full breakdown of the technical scores for those three categories?
I recall that being requested, yes.
And you did not have it with you to provide us?
I believe the response was that the requirements being asked for should be sent us in writing, and we'll respond based on guidance given to us.
But you understand what a debriefing is, yes?
Yes, I do, ma'am.
Right, that the bidder is coming to you and wants to understand their scores in respect of a particular exercise. Correct?
Yes, ma'am. Mm.
So one would expect that you, as a responsible public officer, coming to a debriefing, you would have had the bidder's scores in front of you.
Yes, ma'am.
Did you?
Yes, we did.
Oh, so you had the bidder's scores in front of you and you chose not to provide the breakdown of that 68?
Well, the breakdown of that 68 was provided to Amalgamated prior during the notice of award document being issued to them, which contained all the scores.
Yes, what was on that notice, I don't want to have to put the document in front of you, was that they got 68 points. There was no breakdown. I'm putting that to you. There was no breakdown. It was 68 points, and Amalgamated came to the debriefing asking, how did I get 68 points for resource capacity for these things? How did I get 68 points? I am actually the incumbent supplier on this, not so?
That is not correct, ma'am. Amalgamated wasn't the incumbent supplier on the terminal contract.
Well, terminaling and refinery were one contract in July.
No, they were separate, ma'am. No, they were separate.
They were separate lots in one tender exercise.
In the October tender, this tender that was completed, the terminal contract was separate from the refinery contract.
Yeah. In the October exercise.
Correct.
Okay.
The terminal contract is not awarded to Amalgamated at this time. They are awarded the refinery contract, so they are the incumbent on the refinery contract.
Yeah, but the refinery at that time included everything.
I'm not clear on the question.
So earlier it didn't include terminaling. It wasn't one thing. I'm asking.
No, I'm not clear on. I'm not clear on exactly what you're asking.
So you had a separate contractor for terminaling?
That's correct.
So terminaling and refinery environment were two separate contracts before October?
That is correct.
Oh, okay. Okay.
Yeah.
Good to know. So you, in the notice of award, you said 68 points, correct? Yes?
I believe that
Did
is
not-
what it said.
You did not provide the breakdown. Yes?
We
Then-
did not provide it during the debriefing
No,
meeting.
no, in the notice that you, of standstill and the award of the contract, you did not provide the breakdown of that 68 points, correct?
I accept that that is correct.
Right. In the debriefing, you indicated that Amalgamated got 0 for resource capacity out of 40. Well, 0 for resource capacity. Yeah?
Okay, yes, ma'am. Mhm.
You would accept that if Amalgamated did in fact get 0 for resource capacity, as was stated in the recording, and we have the recording of it, the maximum that Amalgamated could have gotten for technical criteria would have been 60 points, 30 for worker experience and client reference, and 30 for execution plan and quality assurance. Would you accept that?
I would accept that that would be correct.
Right. And so when you then pursuant to the written request for disclosure for the breakdown of the points, because you did not provide the breakdown of the points Amalgamated the debriefing, did you? You did not
Pursuant
provide
to,
it.
Mhm.
You did not provide the breakdown of the technical evaluation criteria points at the debriefing meeting, did you?
No, we did not. No.
Right. But after Amalgamated wrote later that day, after the meeting, you then took several days, and on March 23rd, you wrote and indicated, oh, for resource capacity, Amalgamated actually got 10. And they got 30 full marks for work experience and client reference. Yes? And 28 marks for execution plan and quality assurance. Is that correct?
I believe that is correct.
Right. Now, it is true to say, and I hope I don't have to pull up the documents, that in the invitation to tender, the ITB actually, invitation to bid, you at no time at all in that invitation to bid had any breakdown of resource capacity, those 40 points. You never had any breakdown of resource capacity into a category A, category B, category C. You had none.
That is correct.
That is correct. And you indicated in the debriefing that they got 0. Then in March 23rd, you indicated, oh no, they didn't get 0
Oh,
for
Chair,
resource capacity.
Chair, no. You have to let him answer the question.
Sorry.
Yes,
Sorry, yes.
Let them, yes,
Okay.
you ask a question and move on. So the question I believe Ms. Rose is asking is that he indicated in the meeting something. I don't want to think. So I think you should answer that question and then we move on. Did he indicate anything in the meeting? No. The question is important. Did he indicate anything, any score in relation to resource capacity at the meeting? Because that's where the confusion is taking place. So I don't know, let him answer.
Well, let me ask a question. Paria indicated at the debriefing meeting.
That's not the question that was asked. You said
Well,
him. You have to say him or Paria. You have to choose.
I don't know if my learned friend is trying to tell me how to ask the question. If he's
But you-
taking an objection to me saying he, because maybe the words didn't come out of Mr. Subaru's mouth, this was a debriefing meeting that Paria had 3 representatives at, and this witness has already said that at the
No.
meeting, this witness has already accepted.
No.
Well, we're gonna have
Maybe
to
you
go
should
back.
ask the question. You should ask the question to get it clear.
No, I will ask the questions that I would like to ask, okay? And the point that we are trying to make is for this witness to confirm what you already said, that Paria at that debriefing meeting indicated that Amalgamated got 0 for resource capacity. Do you want me to play the recording, Mr. Subaru?
Let him answer the question. Objection. You have to let him answer the question.
It's about to, but you're jumping in now.
No, you said you jumped in about playing a recording. Let him answer.
Just, can we move on?
Members, please. Minute members, please. Miss Dr. Rose, could you rephrase the question, please, re-ask the question.
At the debriefing, you indicated to Amalgamated they got 0. When I say you, I mean Paria. Representatives of Paria indicated that Amalgamated got 0 for resource capacity. This was asked and answered. I am moving on from it, but yes, you can answer again.
I did say that it was the fact that it was said that the score was 0 was specific to a section of the resource capacity.
No, you said that you said that in the debriefing. Did you indicate that in the debriefing?
No, I'm saying that there was a discussion about that. I didn't say it.
Okay, in the debriefing, let me hear this because we are going to have to play it because we have to be fair. In the debriefing, you are saying today that it was told to Amalgamated that there were breakdowns in resource capacity, and in one of them they got 0?
As I said earlier, I can't specifically recall what was said because there were 3 different debriefing meetings on that morning.
Right. All right. Okay, so I put it to you that what was said is that resource capacity was 0. And we have adduced the evidence to that effect, and the panel will take notice of it. Now,
Dr. Rosa, just want to let you know there are 5 more minutes. So just let you know in terms of for you do have your 30 to 40 minutes with the other witness as well.
but I may have to just go into that 30 to 40 minutes with this witness because we are not all there, okay, on this issue. Now, you have accepted, let me ask you, I just want to make sure before I go on, that in the invitation to tender, there was no breakdown of different sections under resource capacity. That is correct.
That is correct.
In fact, there was also in this tender a missing table too. So for technical criteria, is that not correct?
That is correct.
Yeah, so this thing about it was higher standards and all of that, but I move on. Now, you said that Amalgamated did not get top marks on resource capacity, we go in that way, because they did not have these 26 profiles, correct?
They did not meet the requirements in terms of the 20 profiles for security officers and 6 profiles for estate constables.
Okay, so you personally checked that?
Yes, I did.
All right, on this, I think I may have to show the witness the documents. So can we have, it's our format. Format page 1794. And as we're looking for it, let me just continue. And in this particular exercise, 1794, thank you. In this particular exercise, well, we have it up on the screen, so let's go forward. We see terminaling facilities. You see 6 names here, yes?
Yes.
6 at the corner. And then you see 20 on baton, right? These are the officers you are talking about. Keep scrolling. Can we continue to scroll down, please? And you see 2 more under CCTV operators.
Yes.
Right. So the officers that were CCTV operators, you see baton next to their names there?
Yes.
Have you gone through all of the profiles of the officers? Right. It is true to say, or else we'll have to scroll down into all of them, that these 2 officers, Karen Gill and Mary Fuller, met the requirements, the minimum requirements for the security officers under the 20 profiles.
No.
The same requirements.
No. If you scroll down one page,
Yeah, let's do it.
just to the next, right there, we specifically asked what position to be assigned. And under those two profiles, they were to be assigned as CCTV operators. So they were not assessed as security officers.
So you did not assess them as security officers. Where in your ITB did you say that even though they had the qualifications to be security officers, we are not going to hold them as security officers? Where in your ITB? Can you point us to that?
We didn't specify that in the ITB, but we asked the bidders to specifically identify what position they are being proposed for.
Wow. Okay. Now I'm moving on that point. We can go. Now we understand that the factual matrix in this particular exercise was that when you counted the 20 officers, you found that 2 of the 20 officers under security officers, you found that their profiles were missing, yes?
We did not find the profiles amongst the submissions.
Right. So yes, you have a
Yes.
difficulty saying yes? Okay. Thank you. And so you did a request for clarifications and you specifically said, we don't want you to give us this thing. We just want to know where it is. Yes. Do not submit and underline. Do not submit. Do not submit. You remember doing that?
That's correct.
Right. And the Amalgamated said, but look, these 2 names are on it there. There was some technical glitch, either on our side or their side. It didn't go into detail, but some technical, it wasn't uploaded, those 2. Yes?
That's what they responded, yes.
But you decided to then say, okay, we don't want you to submit those 2, which names were already there. We know you have 2 other officers with profiles whose names are on the list and their profiles are there, who are qualified to meet the minimum requirements that you stated in your ITB. You decided not to go with that and say, well, okay, they have the 2, they have 2 more, they've met the requirement, and you decided to apply some secret requirement. Is that what you just said?
No, that's not what I just said.
You decide, because you just
Chair.
told me, wait,
Chair.
I'm not finished. You
I'm
just told
sorry,
me.
Dr. Rose.
Chair, it's just that in that
I will have
No,
to
no, no,
request be put out if
it's
you
not
don't.
it's not me giving anything. He doesn't have to go. I don't want to say monologue, but there were 6 questions being asked and he didn't get a chance to answer any. So all I would ask is that the questions be broken up very clearly or intelligibly, because there was a long narrative. And then is that what you did? Is that could become very confusing and be misconstrued as the evidence. So I would simply ask Dr. Rose if the questions could be put perhaps in a simpler way. That's all I will say.
I can do that. We don't need to
Yeah, thank
spend a lot
you.
of time on it. Right.
Yeah.
So, because I'm just bringing it together, all that you've already said, but I will break it up again. So you had a bidder that had 28 profiles and a list with 28 profiles. Is that correct?
We had 28 profiles listed, well, 28 names listed on the submission.
Right, 28 names listed, but when you went through the profiles, there were 26.
That is correct.
Right. And the requirements under this ITB were for 26 officers, 20 security officers and 6 estate constables. Estate, yes?
That is correct. 20 security officers, 6 estate constables.
And we accept, so I don't have to say it again, that they had the 6 estate constables, correct?
Correct.
All right. And so for the 20 remaining officers, you requested clarification on 2 of the names in a list of 20 out of the 22, correct?
We requested the profiles, where we could find the profiles for 2 of the names listed under battle officers,
Yeah.
under security officers.
Yes. because you couldn't find those two of the profiles.
That's
Right?
correct.
It's true to say that all of the profiles for security officers, all the 28 names on the list were followed by 26 profiles.
That's correct.
Your requirement indicated you wanted 6 estate constables profiles, which you got, yes?
Yes. Mhm.
And your requirement indicated you needed 20 security officer profiles, yes?
That's correct.
Which you got, yes?
We got 18
Plus 2.
proposed for the position of security officer.
But you just accepted, and let me just go it over again, that in the ITB, you didn't stipulate that it had to specifically be assigned.
We did indicate that the position must be indicated on the officer profile.
Yes, but all of the profiles were there, one after the other, not so? These
Yes.
other 2 profiles were in that exact same section where you are looking for 26 profiles. Is that not so?
But the names weren't in the exact same section on the listing.
Well, there was no separation when you go through the 26 profiles, you know. There's no separation.
There's a
There's-
separation
There's
on
a
the
cover
listing.
listing. Yeah, there's a cover listing. Yeah. But you would accept that those 2 security officers were security officers meeting the conditions of the ITB. The 2 at the bottom.
Those 2
That's-
were not assessed because they weren't designated for the position.
They weren't in the right place.
They weren't listed as to be proposed for the position of security officer.
They weren't in the right place. Now, there was another clarification in this particular tender exercise relating to list of regulatory notices. That is a requirement in the is it the HSC? In the health and safety, that there was supposed to be, bidders had to put in their list of regulatory notices served on the contractors. Yes?
I believe that was part of the HSC evaluation.
Yes, it was. And on your HSC evaluation, you were to get 5 marks for that. Yes?
I wouldn't be able to speak specifically to the HSC evaluation as that was done by the HSC Technical Authority.
Okay, so you can't, but you had overall purview of this tender exercise, did you not?
Yes, we would have received the feedback from the HSC Technical Authority as to the outcome of that assessment.
And you must have looked at what the HSC evaluation, you are the one, you said, like in your witness, you compiled these things, not so?
Not the HSC evaluation, no.
All right, so you didn't look at the HSC evaluation at all then? You didn't know anything about that?
No, I'm guided by the technical authority on that subject.
So who sent the request for clarification? On the 8th of December, 2025, saying that they couldn't find the list of regulatory notices.
I am not sure.
It wasn't you.
No.
All right. Now, you understand what list of regulatory notices are? What is
I believe I have an understanding of it.
what are they asking for there?
List of notices from OSH with respect to health and safety matters.
Right. Notices basically saying, warning you don't have this, you haven't done that sort of thing, yes?
I believe that is what it is.
So if you don't have any regulatory notices, one assumes you'll get top marks. If you have regulatory notices, you will get less marks. Correct?
I can't speak to how that section is assessed.
Is there anybody in Paria could speak to how that session is?
The technical authority, which would be the HSC person that was assigned to evaluate.
All right. Okay.
Dr. Rose, just a minute, please. Mr. Taklal Singh has his hand up. I'm just letting you know that you, according to the time, I think you have 6 more minutes for this. If you wish to keep your time equal. Mr. Taklal Singh?
Well, Chair, I was just about to object to that question because the witness has said that's not his, and I suppose that's one of the problem of not pleading specific things in your case. He can't be expected to answer that. There's an obvious answer, which I think everybody knows, in terms of the communication. But unfortunately, he can't answer that. I could put it in submissions for what it's worth.
Members, my team is telling me that we have a bit of a technical issue on this side. So if we could stand down for, how long we need? 5 minutes? Thank you.
Obliged.
Member, thank you. Dr. Rose, I just wanted to let you know that perhaps you could take 5 minutes to wrap up because you're sort of past your time for your first witness. So if you would like to just wrap up with this witness first.
Yeah, grateful. So in your, so in the ITB, did you indicate that if you did not have these profiles, you would be eliminated for resource
No.
capacity?
I don't think that was explicitly stated in the ITB document.
Right. And there was no breakdown or count for the number of profiles. You just basically said, in this particular section, there are 18, only 18 and 6. And so therefore, it does not meet the 20 and 6, and therefore they will get 0 for the security officer profile section, resource capacity.
Not clear. When you say in the breakdown, what exactly are you referring to? What document?
I'm talking about resource capacity. I'm trying to understand how out of 20 and 6 requirement for 40 points and a bidder submitted on your case, I am saying we submitted all 26, but you are saying no, because those 2 were not part of this. It's only 18 and 6. And I'm saying on that basis, they got 0 for resource capacity.
Yes, they got 0 for resource capacity in that section.
In that section. And because you all didn't give points for the profiles, for each profile, or break it down in any way like that.
There was a breakdown, but not per profile.
Not per profile. Because you would accept that is the majority of officers were there.
There was a minimum requirement, which points were awarded for.
All right. And just one last thing on the regulatory notices, which you said that you didn't know anything about, but you understood that clarifications were sent in respect of that?
Yes, I understand that there was a clarification request in that respect.
And that was responded to. The email that they were supposed to respond to was contract_services_enquiries@paria/pt.com.
All clarifications are required to be responded to that particular email.
To that particular email, and who deals with that email?
I believe that is procurement.
Right. Okay. All right, I will stop here with this witness. Thank you.
Thank you, Mr. Taklalson.
I have one clarification question. Actually, you know what, Chair? No, I put it in my written submissions. I was going to clarify the issue, the points, but I'll put it in the written submissions. Doesn't make sense.
Sure. So I believe the panel, any other question?
Yes, Mr. Subaru, are you hearing me?
Yes, sir.
So you had indicated you received in the proposal all 26 names, 24 battle officers, 6 for estate, but 2 of the battle officers, they were listed as battle, but in the position assignment, they were assigned to CCTV. That's correct?
That's correct, sir.
And those are the ones that were discounted.
Those weren't evaluated, sir.
Did we request any, or did we make a clarification request to the bidder?
Yes, we did. We requested to be pointed to where to find the profiles for the 2 candidates that were listed under the list of 20.
But did we clarify with them why they were assigned the position of CCTV?
No, sir. We didn't do a clarification for that.
Okay. And one more question, Mr. Subaru. Did we have CCTV requirements anywhere in the scope of the ITV? Is that a requirement?
We indicated that the CCTV is one of the services required, but we didn't specify for the profiles.
So was it expected that members of the count of 26 would have performed some kind of CCTV operation?
Say the question again, sir?
In the count of the 26, was it expected that within that count, some of those names would have been required to perform CCTV duties?
No, sir. The 26 was specific to the security officer and the estate constable position.
Okay. Thank you.
Chair,
I have one question for you.
sorry.
Uh,
Chair, I
Go
have one question arising out of that. You said minimum requirements. Those minimum requirements were in relation to the officers and their profiles?
That's correct, sir.
Thank you.
So Mr. Subaru, there's an email that you sent, and it says, where is it? Oh, and this email is dated the 11th of the 5th, 2025, invitation to tender about a meeting. And there's a clause here. I wonder if you could explain to me what it means. Bidders are asked to pay particular attention to the technical ITB scope of work, pages 2 to 6 of 75-ITB document. Failure to submit any of the specified documents will deem your submission technically non-compliant. Could you explain what that clause?
I can't explain what that clause specifically refers to. I'm not sure I have the context of it.
It's in the email that you're given instructions for submission of the bid.
Is that an invitation
It's
to tender,
attached
ma'am?
as attachment 1. So this is attached to your witness statement, attachment 1.
Okay, right. So that's an invitation email to the invitation to bid.
Yes. Yes. Yes.
So
Can you bring it up on screen, please? Let me bring it up on screen for you.
thank you.
Yeah, okay, scroll down. It was highlight. Okay, right there. So you see just above the red writing, kindly provide a response to the invitation. That those 2 sentences there, particularly the one that says failure to submit any of the specified documents will deem your submission technically non-compliant.
Right, ma'am.
Which document? Okay, yeah.
To begin with, this is a email I received as a copy of the invitation to bid that was sent to bidders. I am not the author of this email.
Okay. But do you know what that refers to?
I would have to refer this to the sender, which would have been from procurement.
Is that Marissa Ragir?
Yes, ma'am.
Okay. All right. Thank you. I'll hold it for her.
Chair,
If there are no further questions.
No question arising out of that observation.
Thank you, Mr. Subaru. You are excused. And
Thank
we
you.
will ask Ms. Ragir to come.
I know.
All right, I think it's fine.
Are you seeing it? Okay.
No, no, Chair, we're not seeing you. Unfortunately, we're not seeing.
We,
tried.
after what you call it, the promise, we will, our camera will come on. After the
It's on
OC.
now.
Good afternoon, Ms. Ragir. Please raise
Hi,
your
good
hand.
afternoon.
Repeat after me. I state your name.
I, Marissa Ragir,
Solemnly swear
solemnly swear
that the evidence
that the evidence
I shall give to the hearing panel
I shall give to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So Ms. Ragir, can you please confirm that you gave a statement in this matter? The document that we have put up on the screen, it's confirmed your signature and date of the document.
Confirmed.
Okay, we hereby submit this as standard and marked with the initials of Ms. Ragir.
Chair,
Um,
just like to indicate before commencement that from my check, there's been about 35 minutes of cross-examination already. I hate to limit my friend, but there was supposed to be 20 minutes per witness. Right?
No, you had offered, sorry, you had offered 20 minutes. I have in my notes that Dr. Rose asked for 30 to 40 minutes.
In total.
In total, yes.
Oh, in total, okay.
Yes, it's in total, yes. So that's, not to limit my friend, I know, to be fair,
Okay.
she has to ask her question, but I'm just saying, and I think my voice is telling now that we're drooping a bit, so you know.
We all
Okay,
are-
so
I
Dr.
do my
Rose,
best. I'll do my best. But we are all, I think, in the
can
same
work with
position
15
here.
minutes.
I'll do my best, Madam Chair. Good afternoon
you.
again, Ms. Ragir.
Good afternoon, ma'am.
And so that we can move more quickly, you have been the contract services coordinator at Paria for how long?
Since the November 2019.
And and you I have it on good information that you are highly qualified in procurement, having completed level 4 of SIPS, yes?
That's
Of the
correct.
Chartered Institute of Purchasing and Supply, and in level 5, yes?
Yes. Yes.
And you report to the named procurement officer, Mr. Mahes, in Paria, yes?
That's correct.
So in respect of these tender proceedings, you had overview of the compliance aspects
That's correct.
Okay? And it was your responsibility to ensure that there was compliance with the Procurement Act.
Yes.
Now, at the debriefing, I'm just going to try to deal with two things. So the first one, I'll deal with debriefing, and then I'll deal with cancellation, okay? And we will see if we can do this as quickly as possible. Yeah?
Sure.
So at the debriefing, you communicated quite a bit on this particular exercise, terminally.
Okay.
Did you would say that you were quite vocal?
Well, I would have answered the questions asked.
Right. And it is in this particular tender that you indicated that Amalgamated did not get past the technical threshold. Yes?
Yes, yes.
And you would have indicated they did not get through the technical threshold because they got 0 on resource capacity.
They would have gotten 10 on the resource capacity, 0 on the security personnel.
I'm not asking you what you said on March 23rd. After you went and you counted numbers or looked at your documents, I don't know. I'm asking you what you said to Amalgamated on the 17th of March, 2026. On the 17th of March, 2026, and I hope we don't have to play the recording because I am under pressure for time. You indicated to Amalgamated that they got 0 for resource capacity and they did not progress any further.
Okay.
Okay? Yes, that is true. That you said
If
that.
that was said, okay, and if I would have said that, it would have been that the resource capacity, under the total resource capacity, they got 10. They got 0 on the security and
I'm
10
not
on the...
asking what you all are saying now in order for 68 points that you put in your standstill notice to make sense. I'm not asking you that question. We know you are coming to say that. But in the debriefing, you indicated that Amalgamated got 0 for resource capacity and were not considered further.
Yes.
And you would accept that in the invitation to bid, that elimination gate in respect of resource capacity was not there. That you would be eliminated from the technical evaluation if you get 0 for resource, if you are found not to meet the resource capacity.
You would have been eliminated?
Yes, you wouldn't progress further in the evaluation.
Okay. I'm not too sure about that one.
Okay, so I'm sorry, Madam Chairman, but at the end of the day, we have our work to do. We are all wilting. I'm going to ask for the recording to be pulled up and played for this witness.
But my objection. My friend's question was about what is in the ITB, not what is in the recording. So if she wants to take us to the ITB, your question just now, my friend's question was whether or not there was some mandatory or minimum or whatever in the ITB that has nothing to do with the recording. She's already answered the issue of the recording. So we don't need to play the recording.
But you don't want me to play the recording. I was past that issue.
There's no need. Yes.
I was saying that this witness indicated at the debriefing that if you did not get through that resource capacity, you would be eliminated and you would not progress further.
Oh, she said that at the meeting. Okay, fine, I don't.
Yes, and she's saying she's not sure whether she said that. Ms. Ragir, did you say that? That if you did not get through resource capacity, you would not be considered any further?
To be quite honest, I do not remember saying that. I can be wrong, but I would like to believe that I did not make that statement.
Because if you made that statement, it would be very wrong.
Correct.
Right. Because nowhere in the ITB is anything like that stated. Is that correct?
Correct.
Because in the ITB, one must get a minimum threshold of 75
Two.
out of 100. And in order to get to the 75, there were three categories: resource capacity, worker, worker experience, and client reference, and then execution plan.
Correct.
Yeah? And it was 40, 30, 30. Right? So there was no information that if you don't get through resource capacity, you would not progress further.
Correct.
Now there's an email address, contracts at.
Contract services inquiries.
Yes. Are you the one that manages that one?
Yes, procurement has oversight of that, meaning all the other officers as well. That is our inquiries inbox.
Right. And so in this particular exercise, you issued requests for clarifications to Amalgamated.
Yes.
How many?
I believe it was two, one under HSC and one under technical.
Thank you. So under HSC, let's deal with that one first because Mr. Subaru couldn't help us at all on it. Under HSC, there was a requirement for list of regulatory notices. Is that correct?
Yes.
And under HSC, you would get 5 marks if you were scored favorably. That's the maximum you could get for list of regulatory notices served on the contractor, correct?
Correct.
And list of regulatory notices. Can you explain what that is?
The technical person in this is Randy, but I can give my understanding of it. What Randy, yes. So what Randy would have wanted to see is that he would look at the regulatory notices in terms of whether the vendor has or do not have. So if the vendor has regulatory notices, he's expected to see that. If they do not have, he's expected to see a letter saying that you do not have any notice.
He's expected to see a letter saying you do not have any notice. Where is that requirement where's that requirement in the ITB? Are you now?
I am just explaining what my understanding of what the HSC evaluator would like to see.
Madam, you're the procurement expert in the room overseeing this entire thing. There is an HSC requirement for list of regulatory notices, and there's a maximum score of 5. You know that, yes?
Yes.
Now, list of regulatory notices, I'm asking you what that is.
That is a list of all notices served against the vendor.
Against the vendor, correct?
Correct.
So if you have no notices served against you, you will get good points. If you have notices served against you, you will get less points. Would you agree?
Agreed.
Now, you, whoever was doing HSC under you, because they're under you, Mr. Subaru could run away from it. But, madam, with all due respect, you had responsibility as the procurement officer to ensure that this was compliant with the Public Procurement Act, yes?
Yes.
Right. So a request for clarification was sent to Amalgamated saying, we haven't seen any regulatory notices. Where are they? Not so?
Yes, we asked if they can identify where in their submission it can be found.
But you also went further. I hope I don't have to put it up on the thing. I hope that you've recollected what is happening. You also went further and said, please send them. Please submit it here by some time. Not so? Yes, you are in that letter, that request for clarifications. You said, we haven't seen your notices. Please submit them.
No, we did not ask them to submit it. We said we did not have it, and if they could identify to us where it can be found.
No, dear. that is what you said when you asked for the profiles. You definitely, in respect of the profiles, said we are not seeing the profiles. That's the second request for clarification. We're not seeing the profiles. Please do not submit it online. Please do not submit it. Show us where they are in the documents.
Correct.
But in respect of the list of regulatory notices, an email sent on, make this bigger for me. And it's at our format at 2510, page 2510, our form 8. Good day. Who is, oh my goodness, it's signed by you, Madam Ragir. It's signed by you. Good day. Madam Chair, if you can put it up on the screen, happy to do it, or I can read it out and she can say whether, thank you. Yes, 25110. Good day. Reference is made to the subject tender. Your submission is currently being evaluated and the following requires your clarification. Kindly advise where in your tender submission the list of regulatory notices serviced on the contractor can be found, example file name and page number. You are required to submit same to contract services inquiries of contract services inquiries at Paria by COB tomorrow, Tuesday, 9th of December, 2025. Yes?
Where is that tender submission? Chair, what is it?
You're required to submit them.
Sorry,
Yes?
1 minute, Dr. Rose. I see Mr. Talclason's hand up.
Chair, respectfully, the
1 minute. The witness is here, please. And I think an explanation of what does this mean?
I'm not explaining anything. All I'm saying is my objection is that the document speaks for itself. The document speaks for you. Don't have to cross-examine on the lines of an email.
But this is leading a witness. The witness is now going to tell me exactly that. I was just about to ask for the witness to step out.
What?
How is the witness going to tell me anything different now, Madam Chair? Is that fair?
Saying a document speaks for itself leads a witness.
Of course it does, because you've answered the question. I'm going to move on, Madam Chair. We will leave it for submissions. Now, the other one, where's the other one? Can we move on, because I'm not going to belabor it. I have very limited time. We can leave it for submissions because I'm now going to show the other request for clarifications for the profiles and how it was treated with differently. There was nothing about requiring to submit same. It was, please do not submit anything. We don't want anything. So 2515, I'm told. What does it say? And you will see the complete difference in the way this clarification was treated. Yes, 2515? Yeah. 2515. Ms. Ragir, is it signed by you again?
Yes. Well, I'm not seeing it, but yes, I sent that email.
You sent that one. Okay, sorry. Thank you. Let me look at this one. It's on me. It's clearer for me here. Yeah, so here you said the subject tender is being evaluated and requires clarification. Please kindly indicate where in your tender submission the profiles are for A and B. You are required to provide a response to the above clarification before Friday, 19th December 2025, before 4 p.m. It must be sent to this email only. Note, please do not submit the documents. So it's different. Would you accept?
Yes, it is.
It is different. And you would accept that with these profiles, not having the profiles, this would work against Amalgamated because they didn't have the profiles that you wanted, correct?
They did not send the minimum profile required.
According, yes. And with the list of regulatory notices, the fact that they didn't have any was actually a positive thing for Amalgamated, was it not?
Correct.
but you wanted the negative. So you say, please submit them. You didn't say, do not submit any documents here. You didn't say, do not submit any documents. Please provide same by close of business tomorrow.
There's a difference though. The HSC document was not, that didn't determine when the vendor passed or failed. The vendor passed the evaluation. The resumes, however, is a major factor in providing the service. So we need to have the resume in order to move forward. And because we did not see it, we thought it fit that we clarified where in your submission it can be found. This was specifically requested.
Yeah, but it was specifically requested list of regulatory notices as well. So please. All right, so that is your explanation for why they were treated differently, and the panel will have our submissions on that. But also, we noted in what you provided to us.
Dr. Rose, sorry, Mr.
Yes.
Clausen. Mr. Clausen.
Every time we make a point, he has.
Chair, I'm objecting because one, that entire line of HSC thing is not pleaded. Absolutely no complaint in either the facts in Appendix 3 or the grounds in Appendix 4. Do they complain about any inconsistency with HSC? And it is wholly unfair to come and ask questions now. So I'm saying, one, that is irrelevant. That is my objection. And two, the time is now 15, extra 15 minutes is now up. So I am not feeling sympathetic anymore given these irrelevant questions. So I think fairness, I kept within my time. The panel must ensure that my friend keeps within her time.
No.
So, Dr. Rose, could you wrap up with the witness, please?
I can do my best to do so, Madam Chair. So you're aware that on this HSE evaluation, amalgamated in the evaluation documents you disclosed to us, in fact, was scored 0 for list of regulatory notices under HSE. You're aware of that?
I cannot recall the point that they got for that specific item.
I will leave
But
it for
thank you.
submission.
Yeah.
Sorry? Yeah. I will leave it for submissions, but you would accept that, well, I will leave that there for the submissions, please. There is one area I also wanted to address with this witness, and that is the reason for the cancellation of the July ITB.
The July ITB was cancelled based on the error that we had with the e-box tendering platform, where when we were uploading the technical evaluation, prices were seen prematurely, the lump sum price.
One moment, please. Sorry, Mr. Taklausing.
I'm objecting. That is not an issue. That is not pleaded. There's no challenge to the cancellation in July. And even if there's a challenge to the decision in July to cancel, there's well statute barred. So totally irrelevant to go down another 15 minutes potentially on an irrelevant and unnecessary line of cross-examination. If my friend wants to make submissions on it, the documents are there. She can do so.
And my learned friend can also make submissions instead of interjecting while I'm cross-examining and then arguing that I have taken up the time.
But you're outside your time. You're outside of your time.
But he is the one dragging this thing out now, Madam Chair. Our grounds are quite clear. What we are arguing about and what we are asking questions about are entirely relevant to the grounds, and we will put it in our submissions. I don't know who Mr. Taklausing is grant charging for.
Sure, Dr. Rose, I'm sorry. We'll allow you 5 more minutes. We'll allow you 5 more minutes to close off.
Yeah, I'm closing off right now. I can assure you, Madam Chair. Yeah, so the reason for the cancellation that you gave in the debriefing was?
For the July tender?
The July tender.
We said that there was an internal error.
You said that in the debriefing?
I want to recall that we would have mentioned that.
All right, I will leave it for submissions. I'm putting it to you that what was said at the debriefing was that there was an inability to extract the submissions. There was a technical error and you were unable to extract the submissions.
Okay.
Okay.
Okay, so Mr. Clarkson, do you have any re-examination?
One question, ma'am, that debriefing meeting, was it to deal with the October tender or the July tender?
The October tender.
Thank you.
Thank you. I'll ask the panel members, any questions?
Maybe one.
Sure.
Ms. Ragir, are you hearing me?
Yes, I am.
So just to be clear, because maybe I'm just confusing the point. The resource capacity scoring, you're saying if you did not meet the minimum mark for that section of the evaluation, then you will automatically disqualify technically?
No.
Or you're not saying that?
No, you had to make an overall score of 75.
So then when the applicant requested to have the missing profiles submitted, why are we saying that's a pass or fail matter?
I'm not sure where that was said that that was a pass or fail matter. The tender clearly identified the submission of 26 resumes, and the vendor would have sent 24 submissions. So we would have clarified if they can tell us where in the tender package we can find the missing 2, and they indicated to us that it was not sent in the original package.
What I'm saying is, just now, when you were giving your testimony, right? You said in the HSC, what was it? The regulatory notices. When you noticed that was missing, we requested clarification from the applicant, and we facilitated them submitting the information relevant to regulatory notices. But for the profiles, we did not allow them to submit because it was a pass or fail issue.
A pass or
Is that
fail issue
what
for
you
the
said,
HSC
or I
item,
understood?
or?
No, you said
No,
the
the
HSC
resume
was
was
not a
pass or
fail.
No, the resume was not a pass or fail. It was
Okay.
scored.
So then just reiterate why we did not allow the applicant to submit those missing profiles.
Because it was explicitly stated in the bid the number of profiles you needed to send, and that is not a clarification. That would have been treated as new information.
Okay, thank you.
I have
Ms. Ragir, I do not think you-
I have one question out of
Go ahead.
that. One question. Is it that the profiles were a minimum or mandatory requirement?
Yes.
Thank you.
Ms. Rugby, there's an email that was attached to Mrs. Subaru's appendix. It was sent by you. I don't know if they could pull it up for me. I just wondered if you could, he indicated that you would be able to explain it. Can you pull that? Okay, so it's the clause that states bidders are asked to pay particular attention to the technical ITB scope of work, pages 2 to 6 of 75 ITB document. Failure to submit any of the specified documents will deem your submission technically non-compliant. Could you explain that, the implications of that?
So under the scope of work. Sorry?
No, explain, yeah.
Right, so in the scope of work, we would have had a section that would have indicated that these documents incorporate your bid submission. And under that would have identified all the items that is required to be submitted as part of your bid. So referencing page 2 to 6 of 75 would have identified that area in the scope.
Okay, and
it was just to
fail
reiterate where you can find it.
Okay, but the clause failure to submit any would deem it technically non-compliant. meaning it would not progress to the commercial stage.
Yeah, we will not be able to
that correct?
evaluate, yes.
All right. That's it. Take down the screen. But at this time, I just want to know if the parties wish to rely on written submissions filed, or if they wish to file final closing submissions, and if so, we are asking you do so by the 24th of April by
That's
6
tomorrow.
p.m.
6 p.m. Morris.
Chair, I would and I would make this point, I would like to exercise the option to file the written submissions by, I think Ms. Rose needs until 6 p.m. tomorrow. Yes, 6
Just
p.m.
1 minute,
tomorrow.
sorry. 1 minute, please. Sorry. My bad, Ms. Ragir, thank you. Can we
Yes.
excuse her?
Yes.
Right, apologies.
Yes.
Yes, Mr. Takalasan.
Yes, Chair, we would exercise, and I think Ms. Rose needed until 6 p.m. tomorrow. Which is fine by me, of course. So I have no difficulty. We can file the submissions by 6 p.m. I think submissions are required, especially our witnesses are very tired. So we need to explain things fully. Yeah.
Thank you. So I want to thank all of you. It's been a long day. Thank the witnesses. Thank you for your assistance. Thank you for your patience. We expected this decision has to be given on or before the 28th of April in accordance with Section 5011 of the Public Procurement and Disposal Act. And it will be issued to you by email from the hearing secretary. Written reasons will be then statutorily due within 30 days after our decision is given in accordance with Section 5012 of the PPDPP. I want to thank you once again and have a good night. Okay.
A work-filled night and
Not good
no
afternoon. Good. This says
proceedings.
good
Thank you.
afternoon, but good night.
Are you coming, man?
Thank you, Madam Chair.
Before this panel. Oh, she done. Oh, okay. We back. Chair, yes, good night. Have a good night. She gone. Miss Rose, why all this fight? Huh? You like the fight?
Can't we just get